number one source, Sports Card Nation. The hobby is the people. Sports Card Nation.
What is up, everybody? Welcome to episode 367, Sports Card Nation. My guest this week has been on the show before. He'll be on the show again. He'll be on the show the next 4 episodes. They are smaller episodes, so don't panic. That's why we recorded one long conversation, but I'm going to make 4 episodes out of them this week and the next 3. I think you'll find the episodes very interesting, to say the least. My guest, the hobby lawyer, Paul Lesko. And we're going to talk about some of the litigation going on currently in the hobby, pertaining to the hobby. And Paul is obviously a lawyer. You just don't call yourself the hobby lawyer and not be a lawyer, just like I'm not Dr. Newman, MD, because I'm not, but he is a practicing attorney, a very smart and knowledgeable one, and a great guy, and always love having him on. And so in the next 4 weeks, again, the episodes are going to range 15 to 22 minutes. We're going to chop up some of these cases and what it might mean for the hobby. And some of these cases you may be very familiar with, and others maybe not as much. Some of the cases, we're not going to all talk about them on this particular episode. Some of the cases you're going to hear about is, hey, where's my Honus Wagner? PSA damaged my Kobe card. Lorcana versus Upper Deck. Panini versus Fanatics. Wild Card versus Panini. My PSA 9, I want to be PSA 10s in the Spiegel Golden case. So, you may not realize there's a lot of litigation hobby-wise going on in courthouses around the country. And while you may not be into that stuff, and I get it. Has nothing to do with your card collection directly per se, but it does have a direct correlation on the hobby and what might happen in the future and what these companies may or may not be able to do in the future based on the outcomes of these court cases, right? So we're going to chop up some of these each week, the next 4 weeks, starting with today. And I'm calling today's episode, Dude, Where's My Honus? And I think you'll find it very interesting. And, I'll say this at the end too, but let me know what you think about today's topic of litigation. And I'll just tease you with that. It's definitely a very, very interesting case. And when I learned all the details about it, it was, why did someone wait that long to file it? That's as much of a tease as I'm going to give you. So we're going to get Paul Lesko on, and we're going to chop up that case. Thanks, everybody. Enjoy the show. I always love having the next gentleman on this podcast. He's a multi-time alumnus of the show, and it's been a bit since we've had him on again, and there's a lot of new stuff to bat around here. And we know him and love him as the hobby lawyer, Paul Lesko. Welcome back, as always.
Thanks for having me back on, John. It's been too long.
Yeah, it has, and that's my fault. So I'll fall on.
We're all too busy. We're all too busy.
And obviously we call him the hobby lawyer, and he's obviously a lawyer and a hobbyist, and he loves to really break down some of the ongoing litigation going on when it pertains to the hobby. And like I spoke to him before we're recording, whether you're into this stuff or not, right? This still is important to present tense of the hobby and the future of the hobby. So while some may have more of an interest in these kind of conversations, that doesn't diminish the importance of these cases and the decisions when they come involving these cases. And so, like I said, it's been a bit, so we definitely got some stuff to toss around. I love Paul because he makes it easy to understand, right? I think sometimes when we get into like legalese and litigation, people can be intimidated and like, I'm not going to understand it, or what the heck's going on, or what does this mean? But you have a wonderful way of sort of making that consumable. Even in your social media, you're very detailed and obviously verbose wise, even more so. So let's start. No, you're welcome. It's true. Let's start off with a question. AI is a huge topic across many different facets and topics and different things, right? It's huge, right? And it's got its good points and its bad points both. And I just, we got, people can cheat with GPT on like schoolwork or coursework. You can do like these fake videos that almost look real. I got to ask you, Paul, please tell me there's no lawyer GPT or lawyer AI to replace one Paul Lesko and other lawyers who did their work and got their law degrees and things like that.
Well, luckily at this time, no. And there have been actually some cases where people have argued that Chat GPT is my lawyer. I'm relying on Chat GPT for what I'm doing. And there was a recent decision that came down where a judge said, no, lawyers are licensed. Lawyers have gone to law school. They've taken the bar exam. Chat GPT, at least as of now, is not a lawyer. However, too many people are relying on ChatGPT as their lawyer, and it's starting to affect the hobby litigation in the hobby.
Now, when that ruling comes down where a judge says, "Listen, you ChatGPT is not official, licensed legal attorney, it can't be used." Does that set the precedence where that speaks for that ends that as a potential down the line, or not necessarily?
It's already been a standard rule that in order to represent somebody else in court, you have to be a licensed, you have to have passed a bar exam. So that's always been the rule. So when people are trying to rely on AI, that's where that rule comes in. So it's really just judges clarifying that no, ChatGPT is not a substitute for an attorney. And part of the reason isn't just because it's not a person; it hasn't gone to law, but it's also because it makes a lot of mistakes and gets a lot of people.
No, and an attorney themselves is not taking that case for a client like that. That ChatGPT can be officially viewed as legal. I would hope not. They're practicing against their own profession if they would represent someone that's claiming that or trying to use that.
Yeah, no, and it happens a lot on both sides of the fence. So there's a couple cases out there right now currently having to do with trading cards where you have pro se plaintiffs. Those are plaintiffs that are in court without lawyers. They're representing themselves. And it appears that they are using Chat GPT to generate their pleadings, to generate their argument. And it's getting them into a little bit of trouble in their cases. But also, there's at least one example where lawyers were using ChatGPT to make their workload lighter, and they got caught during doing it because the ChatGPT made up precedent, and the lawyers didn't go back, they didn't check up on it. And it's fascinating. It was actually a case against Panini, and the lawyers on the other side filed a brief, and in the brief was a bunch of case law. And Panini's response to that brief was, "Your Honor, we think AI wrote this because none of these cases exist. We looked them up; they don't exist, and they cited them to us." And in that case, the judge actually reprimanded the lawyers on the other side. So it's not just people without attorneys relying on ChatGPT or other AI. There are some lawyers out there that are doing it too, and at least as of now, you probably don't want to do that.
That was my next question. Yeah, and you mentioned like the judge, sort of scolded the lawyers for using that tactic. Can there be harsher? Obviously you're not going to get disbarred. That's harsh. Can there be like a financial fine, or can there?
There has been. There were two cases, or there's multiple cases that are out there. The Panini case, that one by itself, the judge not only reprimanded the lawyers, he required them to report it to the bar. So they had to tell the bar that
Self-report.
that they relied on ChatGPT. They got case law that didn't exist, and they relied on case law that didn't exist. But beyond that, and I follow this because it's fascinating. It seems like every day there are lawyers in other types of litigation that are getting sanctioned, and it seems like the standard is about $1,500. Lawyers getting sanctioned for inventing cases or relying on AI that invented cases. So yeah, there's been a lot of lawyers and sanctioned relying on AI.
And so those sanctions would come from the bar itself. That would be
It'd be
their
from the lawyer.
ruling when.
The lawyers themselves or the law firm itself will have to pay that.
Yeah. Can the bar, like you mentioned, like they have to self-report their indiscretions to the bar? What can the bar do? Obviously, if it's the first time offense, maybe a slap on the wrist or like you're better than that. Don't. But if an attorney becomes sort of a repeat offender, can there be even more serious repercussions?
There could be, because the number one thing that the bar is looking at is, are you zealously representing your client? Because not when a lawyer is relying on case law that's been fabricated or doesn't exist, they're hurting their client's case. So maybe in an instance where it was a motion that didn't really matter that much to the case, it's more embarrassing than anything else. That'll be something where the bar exam says, okay, just this is your one strike. We're gonna watch you. Now, if it was done in an instance where it really hurt a client's case, the bar might look at it a little bit more different. But at least as of now, and I'm not ultimately current on this, I don't think anybody has yet been disbarred for relying on AI. But it's only been around for a couple of years right now. So it's only been, I'd say mainstream use for the last, year and a half, 2 years, especially in the legal field. Legal field's very late to adopt a lot of technologies. So it wouldn't shock me within the next year if we don't start seeing people, if it already hasn't happened, see some lawyers disbarred due to their reliance on AI, especially if they're repeat offenders.
How easy is it to tell? Like I've used it for some like social media, like making graphics and stuff. Not so much for writing, but like if something crosses your desk, I mean, how easy do you think it is necessarily to tell, I guess it depends on every situation's different. To
Yeah,
you, do you think it's go ahead?
Yeah, no, I see it actually quite a bit. And so for some of my clients, what I do is I represent copyright holders, so like artists. And invariably there are a lot of infringers that are out there. Some are, small infringers on eBay or other places like that. So, part of my job is to shut them down, get into communication with them and, explain to them that you're ripping off my client's rights, need to stop. I'd say probably 1 out of every 3 tries to respond to you with ChatGPT, some type of response like that. So I've gotten pretty attuned to seeing what a ChatGPT response is, and you could tell because as a lawyer, you're taught to, point to the statute you're relying on, point to the case law that you're relying on, point to the specific facts that are in your favor. A ChatGPT response is more going to be along the lines of, well, as everybody knows, there's this general this. And you can really quickly get to the point that they're using the AI and get around it by saying, okay, I need you to cite to a case to me. I need you to cite to the facts that actually support you here, because you're regurgitating a lot of stuff that sounds like you know what you're talking about, but you're not saying anything. And then when you get to the point of where they have to specifically identify case law in their support the position or facts, they normally can't do that, and that's the point when they settle.
Yeah. So you can't fool Paul Lesko, folks. That's
Well,
what
hopefully not all the time.
All right. Let's before we get into litigation, which I enjoy, and I know quite a bit of people do. I know a lot of your personal collection comes off of some of this litigation. Without going, when we can cover some of these cases, but has there been any new PC items on the target list as a result of some of these?
I do have quite a bit actually. So, but this is my current pride and joy. So I picked this one up at the National this year. I chased this card since 2011. So it is a card that was involved in a lawsuit that was brought against Topps by a former Topps employee saying, you utilized my image on cards without my permission. And why it was so difficult for me to get that card is because there were only 5 of those cards that were made. And back in 2011, the card popped up right when the lawsuit was, and it was on eBay. And at that point, I hadn't spent even close to $100 on a card. I was, just I wasn't spending much money on collecting, and it was back in the good old days where you didn't have to really spend that much money to get good cards.
Yeah.
So I saw the card. It was on eBay and it was going for $200. And in my head, I'm like, I can't justify spending $200 for this card. It's numbered out of 5. It might take a while. Another one will pop up on eBay, guaranteed. Well, no, I was wrong. Another one never popped up again on eBay. And the only reason I got this card is because every year before the National, I whined and complained about, hey, this is like my white whale. I can't find this card. Does anybody have needs on it? And somebody reached out and said he'd seen my posts, for a few years, and and he finally said, okay, you know what, this card, I can get this card to a good person, someone who's actually going to enjoy the card and actually love the card more than I would. So we were actually able to put together a trade and get it done. So that is the glowing part of my collection right now. It was my white whale. I was able to secure it. And really, since that, I have this like profound sense of finality where I'm not on eBay every day now. I've got what I need, So I really need to have that next lawsuit that comes up with an obtainable card, something I can add to the collection. Because I think a couple of the cases we're going to talk about today, they're not obtainable cards because the cards are, several $1 million worth. That will never get into my collection. However, if you have a card that's worth, a couple $100 and there's only 1 or 5 of those that are out there, I think that'll be a good card to add as a few.
Yeah, and I remember you when you posted about finally getting it. That's awesome. And the search is over, as Survivor sang in one of their songs, right?
Yeah.
But like you said, stuff was maybe certain things were a little cheaper 11 years ago than they are today. So whatever the next, Paul Lesko Target card is, probably going to be maybe a little bit more than that one. You never know.
Unfortunately.
Every situation is different.
You are listening to the Sports Card Nation podcast. We'll be right back after this break.
For nearly 50 years, Sports Collectors Digest has been the voice of the hobby, bringing you comprehensive coverage of the sports collectible industry. From industry news, auction results, market analysis, and in-depth stories about collectors and their collections, Sports Collectors Digest has everything you need to know about the hobby. SCD is also your leading source for listings of sports collectible dealers, card shops, card shows, and the latest from the industry's top companies. To check out all the latest news or to subscribe to the hobby's oldest magazine, visit sportscollectorsdigest.com or call 1-800-829-5561.
We are back.
Well, let me ask you this. I'll acquiesce to you. You're giving of your time to show. Where do you want to start off here, litigation-wise? What do you think?
Let's continue with that AI topic, because there's a couple of pro se cases that are out there. Actually, more than 1, 3 pro se that are out there that I am not 100% certain that they're AI cases, but I believe that they are AI cases, or that the plaintiffs in those cases who don't have lawyers who are representing themselves are relying on ChatGPT or another AI, and I don't think it's helping them much. So the first case I want to talk about is the case that I've called that Beckett lost my T206 Honus Wagner 12 years ago. And this is a case where the plaintiff alleges that 12 years ago he had car. He bought some cards, and I don't exactly remember where he got the cards, but within the cards that he had, one of them was a T206 Honus Wagner, and so he submitted that card with a bunch of other cards to Beckett to get graded and to get authenticated. and he didn't get the Honus Wagner. He alleges he never got the Honus Wagner back, and he just assumed that if he didn't get it back, it wasn't authentic, and he just forgot about it for 12 years until he logged into his.
I gotta stop you, Paul. I gotta stop you. Even 12 years ago, like I know that card has went more in recent years than in past years, but that card didn't sneak up on anyone.
No,
Like that card, and I know you're going to get into the nuts and bolts, but that's not a card when it doesn't come back. You don't say, "Hey, where's my Honus Wagner card?" Or you at least would ask an explanation, even if you thought, well, it was obviously fake, and that's what they. Like, you would still question, like, well, all right, where is it? And frankly, I'd still want it back. I still want, like, it's my card, fake or legit. Like, and then, like you said, all these double-digit years later, that just, to me, again, I'm not a lawyer. That's why you're here. But to me, I would, like, that shouldn't even, like, why are you waiting that long to, like, now bring it to litigation? But good. I just wanted to chime in, just because hearing you say that, that's how my mind works. Like, where you been? Like, have you been in a coma?
Yeah,
and you woke up and said, "Oh, I meant to do this."
Yes, I mean, so 12 years ago, I mean, I'm pretty sure 12 years ago, that's when the Mastro trial was ongoing. And part of that was, there was a lot of talk about, did he trim or did he not trim a Honus Wagner card? So, I mean, even back then, it was still and I'm not sure when that was the number one card, the first card that PSA graded, if I remember correctly. So that card is not sneaking up on anybody. That's a well-known card. But the plaintiff alleges that 12 years later, he logged into his Beckett account, and he says that the Beckett account said that the card was authenticated, that Beckett said it was authentic. So at that point, he contacted Beckett. He says, "Hey, where's my card? I want my card back." And Beckett says, "Well, it was not authenticated. We couldn't authenticate it. We didn't think it was real. And if it didn't get back to you, well, it got lost in the mail. And because it happened so long ago, we don't have paperwork about it. FedEx doesn't have any paperwork about it, or whatever courier has it. Nobody has any paperwork about it." So that didn't make the plaintiff happy. So he sued Beckett over the card, and that lawsuit is what's going on. And I mean, and you kind of hit the nail on the head there. There's a defense. There's a legal defense out there called the statute of limitation. You have to bring a lawsuit within a certain time period. And the reason those exist is because judges want issues before them that are ripe, where you have like the most materials are available. Witnesses are still alive. Documents still exist. It's still fresh in everybody's head. As time goes on, you lose documents, people pass away, people's memories. So that's why you have the statute of limitation built in. And as you can imagine, that's what Beckett has been pounding the whole time. Regardless as to what the merits are. First of all, we deny everything that the plaintiff is alleging. However, he's out of time. Because he's out of time, we should win. And that's been a real fight. And the case has been kind of a fun one to watch, too, because the plaintiff in that case, since he's not a lawyer, is unfamiliar with the legal system. He's been rather aggressive and has actually filed 5 motions for sanction in the case. It's only been pending for 6 months, I think 6 total months, and he's brought 5 motions for sanction. To put that into perspective, 25 years I've been practicing law, I've only filed 2 motions for sanctions. So he's more than double. He's lapped me and then is halfway to lapping me again with the number of motions for sanctions that he's filed for. And the judges denied them all. But what was interesting is we had an order come down yesterday where a lot of the motions for sanction, he's alleging, hey, Beckett's not giving me any documents. They're destroying evidence, blah, 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 all these other things. The judges pretty much said, hey, we'll get to it in the case. We'll get to it in the case. You need to talk to him. But one thing that the judge said is, I do want some documents that have to, in particular, I want to see I want to see where this card was, who had the card, who was in possession of the card. I want to see the chain of custody from both sides. Now, normally with a motion to dismiss for statute of limitations, you don't get the case just ends really quickly. So I thought it was pretty interesting that the judge at least wanted the parties to exchange that type of document before he rules on the motion. But I think ultimately too much time has passed. 12 years at best. There's very, very few, if any, claims out there that would survive 12 years. So I think I think the case ultimately, I think Beckett will win the case. But to go along the AI side, at some point, Beckett did argue that some of the cases that the plaintiff argued are cases that don't exist. So because of that, they're alleging he's relying on AI in generating his. The plaintiff denies it, but I think it ties in together with this whole AI, in the hobby. And I think we're going to start seeing it a lot more. There's a couple cases ongoing with it right now. I think we're going to see a lot more of these.
I don't know if you can answer this question, Paul. Do you know, did Beckett offer like anything, like an out of court settlement? Like, hey, we'll give you this and let's move on. Do you know if are you privy to that information, or is Beckett saying we'll see you in court? We're not giving you nothing. It's been 12 years. Like, this is ridiculous.
Yeah, we haven't seen anything. Normally, settlement communications are kept secret between the parties. So if there was something out there, we haven't seen it yet. But I imagine here, if I was a defense attorney in a case like this with a statute of limitations that was that long, I would say, let's fight the statute of limitations. Let's see what happens. You don't need to make a settlement offer. If somehow they survive that, well, then let's talk. But given that, this case is a Honus Wagner settlement negotiations, I don't think the sides are going to come or are going to meet anywhere near them, because I don't know about what the current sales of Honus Wagner's are, but I guarantee they're in the $7 or $8 million range, and I don't think anybody for a lawsuit that they think is frivolous will pay any.
Well, again, I'll reiterate. How do you forget that card yourself, right? Number one.
Yeah.
Right. But I want to ask this. Let's just hypothetically say the plaintiff wins the case against Beckett. What is he entitled to? What the price of the card 12 years ago, or the price of the card now? Like, how does that, obviously then there's court fees and like you can, and damages above the price of the card. But just speaking to the card itself, if the plaintiff was to win the case, would he be, priced 12 years ago or current market price?
And that's we really don't have any cases out there that have gotten that far. We'll talk about one a little bit later that might get us there, but most cases settle. And as you can imagine, the plaintiffs are arguing whatever value is the highest. If it was higher back then, if it's higher now, that's what it'd be. And the defendants are obviously going to argue the other. So when if you're talking modern wax, Zion Williamson PSA 10 way back in the day was worth a lot more then than it was now. So, you could see how each sides will pick what value that they want. But also, it depends on your state law. Some states will not allow what's in a breach of contract action, what's called consequential damages, which is an increase in value. So if you had a contract for $10 and ultimately the product 10 years later is worth $50, if you're in one of those states that does not allow you for a contract action to seek consequential damages, you're stuck with that initial $10. Now, so it was that was the big. It depends. It depends on what state you're in, and it depends which side you're on. And we don't have a judge that has chimed in yet to say what controls. So we'll just have to wait and see.
Yeah, that's definitely interesting to see how that turns out. One last question pertaining to that. Mm-hmm. If a judge feels like he's going to rule in the plaintiff's favor, how does he does he determine the amount, or does he go to Beckett and say, I'm about to rule against you, you may want to try to settle? Is that how that works, or no?
Most times people select a jury for it. So the jury will decide which party wins the case, and then they'll decide if the plaintiff wins, who's entitled to what value. So it won't be the judge. So the judge really just decides, is there sufficient facts? Does the law exist to allow a jury to decide? And if there is sufficient law, if the law is actually supporting the plaintiff, and if there are sufficient facts that are in dispute, then he'll give it to the jury. But it'll be the jury that'll decide who wins, who loses, and if the plaintiff wins, how much money they.
Okay, and that's, obviously there's a potentially appeals processes and whatnot. So if a jury did decide in favor of the gentleman whose claims as Wagner never got returned, it would probably behoove Beckett to, obviously they're either going to appeal or they're going to try maybe to get out on the low end of things if possible.
Yeah, if possible. But I think for a case like this, I don't remember what he's asking for, but I think he's asking for somewhere between 20 to 25 million. So I think when you get to that point, I don't think there's going to be a middle ground for that one.
Yeah, that's crazy. And like Paul, I'm a bulk subber for SGC, right? I got $50 cards that people are calling me every week. Like, are they back yet? Are they back yet? You know, like this is a iconic, historic card of the hobby. Like, I didn't forget that for 12 years. And like, that's, to me, that's, I don't know. I just can't fathom that. But
I had a $20 card that bounced all over the East Coast for a month before it showed up. And even that caused me a little apprehension.
Yeah. It makes, it's kind of goofy. It's, you know, but we'll see how that, how long will something like that potentially could be in litigation? Like, how long could something like that drag out?
I would call this a simple case. There's not very many issues that are here. I could see a case like this lasting year to 15 months, depending on what happens. Cases do not move quickly in the court system, and that'll be just to getting a jury trial. If there's going to be an appeal process, we'll add another year and a half on top of that.
Yep. All right. Hope you enjoyed part 1 of 4 with Mr. Paul Lesko, the hobby lawyer. And the next 3 episodes, we're going to chop up some more hobby litigation. And again, while it may not directly affect you, it directly affects the hobby, right? And it's very important to note that. So, and it's just interesting to learn sort of how, you know, the law works and how these cases are decided and who might have the edge in them. So again, always love having Paul on to dissect these cases, make it easier to understand if you're not a lawyer like most of us. And hope you enjoyed it. 3 more the next 3 Fridays. All right, now we're going to hear from our Hobby is the People announcer of the week and wrap up this week's show.
Time for our Hobby is the People announcer of the week.
Hey, what's up? It's your boy Caleb, at Mr. Caleb on Twitter. And remember, the hobby is the people.
If you'd like to be the Hobby is the People announcer of the week, do a WAV or MP3 file and send it to sportscardnationpc@gmail.com.